Joining us now is our defense attorney, Gretchen von Helms, to look at some of the legal aspects in this case. I think it's important, first of all, you just mentioned they both have to have separate attorneys in this case.
Yes, that's required. I wouldn't read too much into their icy demeanor with each other. They have to have separate counsel because judges know that each one may need to say, well, this one did this and this one did this, and they can have antagonistic or conflicted points of view. And so that happens in any case in which there are co-defendants. They must each have their own lawyer, and they do.
But he basically has said it's her fault, essentially throwing her under the bus. So how do those strategies work going into this case?
So going into this case, they're married. They cannot be required by law to testify one against the other. Each can if they wish to, and he could at his own trial testify and blame her, and she could at her own trial. They will be jointly tried, blame him. Now, this is not a new accusation against him because he was told all about this in 2009. He was told to stop. Then in 2010, his own staff said, stop, you need to change how you're doing things. He did not do it. There was repeated warnings, repeated press interviews. So this is no surprise that it ended up in this. However, he was treated very fairly by the prosecutors, who are this apparently Democratic witch hunt. They treated him very fairly. He was allowed to surrender into court. He was allowed to walk out. He was allowed to post his bail at a later time. He was allowed to seek another signature. That normally does not happen. Normally people are arrested, they go into custody, they show up in the back door in a jumpsuit, and the judge sets bail. Then you wait 3 or 4 or 5 days or more to get your bail paperwork in order before you are released. So he was granted an enormous favor by the prosecution team to allow him to surrender in this manner.
So he has said that he wants this wrapped up before November, before the election. What is the likelihood that that will actually happen?
That is not likely because his lawyers are aptly going to say there is a lot of discovery in this case. There's a lot of evidence to go through. It would not be fair to him as a defendant for the prosecution team to have, since 2009, to work on this case, and his lawyer to have a few weeks. So his lawyer is going to have to talk to him and say, look, this is what the discovery is. It's voluminous, or it's a lot of material. I need to be able to investigate it and do a good job for you. So his lawyer is probably going to request that this be delayed until after the November elections.
It will be an interesting few months ahead.
It certainly will. It certainly will. He can. He does have speedy trial rights, though, so he can, if he wishes, rush this through. I don't think it would be doing him any favors to do so.
No doubt. Thank you, Gretchen.